make it clear that the effect of Senator Mitchell's vote on the appeal was to immediately dismiss the threat that that immediately would have come up had the appeal not turned out the way it did.
Thank you. Senator Jaskowski, just a couple questions, but maybe I'll ask after I give Senator Mitchell an opportunity to ask a question. Senator Mitchell.
Thank you, Mr. President. I will keep this quick in the interest of time. Senator Drazkowski, I don't want to assume, so did you personally draft this complaint? And if not, who drafted it?
Senator Jaskowski.
Thank you, Mr. Chair. Senator Mitchell, I personally drafted the complaint with the help of staff. I had my hand fully in the complaint.
Senator Mitchell.
Thank you, Senator Drazkowski. Do you think that if stating a rule, especially in an ethics complaint, it's important to fully state the rule and not be misleading in how things are put in the complaint?
Senator Jaskowski.
Thank you, Mr. Chair. Well, Senator Mitchell, I think we put the quotes in there, and with the understanding that the rules are very well known, very available. I have mine right here, and I'm sure you have yours, and the full rules as well. Phrases were taken from statute as well in the complaint, and that was just a style that I decided to bring forward.
Senator Miller.
So it wasn't to detract or confuse anyone. It was simply the way we wrote it, and to keep it brief, so that just to keep it brief. But the statute is very readily available. All 5 components of the statute that are in 10A.07 that you failed to fulfill.
Senator Mitchell.
No further questions. Thank you.
And Senator Jaskowski, speaking of that, you said that you had an opportunity to read Minnesota Statute Section 10A.07. Is that correct?
That's correct, Mr. Chair. And just to point out that 10A.07 and Administrative Policy 1.35 are both fully incorporated into our rules. Under rules 56.4, under Rule 56.4, both are incorporated into our rules.
And just so that we're clear, Rule 56.4 states that members of the Senate must disclose potential conflict of interest in the discharge of senatorial duties as provided in Minnesota Statute Section 10A.07. Is that right?
That's correct, Mr. Chair.
And if you go to Minnesota Statute Section 10A.07, which is the conflict of interest statute, can you tell me how this statute defines financial interests?
Mr. Chair, I'll read it for you. 10A.07, paragraph A3 or A2 says, A3, I'm sorry. If a member, paragraph A1, hold on. Paragraph B, Mr. Chair.
That is correct. Can you
says, for the purpose of this section, financial interest means an ownership or control in an asset that has the potential to produce a monetary return. And so the asset here is Senator Mitchell's election certificate and the job and the assets that go with that.
And can you tell me in the statute where it says that an individual and their election certificate under those rules that you've stated would be considered a financial interest under the statute?
Mr. Chair, I can't tell you there's any that says it isn't either.
And members, the reason why I'm calling your attention to 10A.07, because the statute is very clear. It says for the purposes of this section, which is the conflict of interest, it says means any ownership or control in an asset. that has the potential to produce a monetary return. So I'm not certain, and in fact, I don't think that when Senator Jaskowski has put forth benefits and salaries and insurance, health insurance, and that will qualify as a financial interest under the statute. But that's my thinking.
Mr. Chair?
Senator Jaskowski, I didn't ask a question, but if you want to say something else, you're more than welcome to.
I was curious if you knew anywhere in statute that says it isn't.
Senator Jaskowski, no, but it's very clear here where it says what is an asset, and it says any ownership or control in an asset, which is usually property or some other business, but it's usually never interpreted as a election certificate. And maybe I can ask Senate Counsel if I'm in error or if she knows of any provision that states that an election certificate qualifies as a financial interest as identified in Minnesota Statute Section 10A.07.
Mr. Chair and members, there is no definition of the term asset for the purposes of Chapter 10A.
Any other questions? Senator Kunish.
Sure. I just did a real quick search under the question, is a job an asset? And while we can't always believe everything on the internet, they did give a really good explanation. It said, while the job provides income and contributes to your standard of living, it's generally not considered an asset in the financial sense. It's a source of income where you trade your time and labor for a wage or salary. You don't own your job. You're employed by somebody else. You can't sell or transfer your job like you can with an asset. And while the job provides an income that you can use to acquire assets, the job itself is not an asset. So I just wanted to put that out there.
Any other questions for Senator Jaskowski before we go to Senator Mitchell?
Mr. Chair, if I could respond to that.
Senator Jaskowski.
Mr. Chair, if this was not an asset, Senator Mitchell wouldn't be so quick to violate our rules in order to maintain it.
Okay. Senator Jaskowski, thank you so much. You will have an opportunity for rebuttal. We will now ask that you sit over there, and we'll ask Senator Mitchell to come to the table. Senator Mitchell, as you're coming to the table, you have the opportunity to speak for 10 uninterrupted minutes. And then once you finish your presentation, the committee can ask you questions. And when you're ready, state your name for the record and provide your testimony.
Thank you, members of the committee. I am Senator Nicole Mitchell, and I appreciate your time here today. I'd also like to say in advance, a couple things that were already touched on are things that I intended to highlight. So if anything gets repeated, hopefully that just emphasizes the point. There has been a lot of discussion so far today about conflicts of interest and when a member can and cannot vote. But what hasn't been mentioned here today is that the ability to vote is considered central in our ability to represent our constituents. In fact, that's part of the very next sentence of one of the citations in Mason's that Senator Jaskowski made. So barring of a vote must be incredibly narrow, to the point that what constitutes a conflict of interest is generally self-enforcing, because we all vote on things that impact ourselves, because we're also citizens of Minnesota. Some of them even have personal financial impacts, such as bonding projects that save money for the very communities that we live in. That gets us to what is required under Minnesota statute, part of which it was cited in the ethics complaint. They wrote that 10A.07 provides a conflict of interest when, quote, in the discharge of official duties would be required to take action or make a decision that would substantially affect the official's financial interests, which we've started to touch on, period. Not an ellipsis in the ethics complaint, indicating that that was the totality of that particular sentence. But in fact, that wasn't the whole sentence. And there was some pretty important stuff after that. The sentence also reads, unless the effect on the official is no greater than on other members of the official's business classification, profession, or occupation. That is why members can vote on many things that impact us, because they're unique to our shared occupation as senators. That gets us to the potential conflict for financial interests. It clearly does not fit here because not only is the alleged financial interest my employment, where I am situated the same as other senators, but more important, the ethics complaint omitted that there was a very specific definition for financial interest in the statute. Ownership, as you mentioned, ownership or control in an asset that has the potential to produce monetary return. Ownership or control in an asset. And I did the same search as Senator Knish did, and it is generally not considered that employment is an asset. But instead, they do talk about ownership, and they do talk about control. So these are things that might uniquely affect a senator, like a company you own on the side. I've heard Senator Miller recuse himself for that reason. Stocks you might have that might be impacted by our voting. A property you rent, things of that nature. This straightforward definition in the statute does not include employment. So the one thing we must excuse ourselves for in terms of voting are conflicts of financial interest, which does not fit my circumstances, even if this had actually been an expulsion vote, which it was not. But here's the thing. Had we gotten to that point, I would have excused myself from that. Even on January 27, with the motion to get to that vote, I had excused myself from a couple similar votes last spring. Not because I was obligated, but completely voluntarily so as not to be a distraction. I did not have time to consider or make a similar motion on January 27th because right away, Senator Frentz jumped up, immediately rose, and explained that per the rules we are governed by, that underlying motion was out of order. President Champion ruled that the motion was out of order, this was disputed, and the only thing I voted on was a purely procedural question about his ruling. There is absolutely no grounds and no precedent that a member would have to excuse themselves from a purely procedural question. Really important to me that day was that because of the shared presidency at the time, my understanding was that the out-of-order decision had actually been put to the Secretary of the Senate, one of our wonderful nonpartisan staff. And I was frankly saddened that his expertise and decision was really what was being questioned at that point. And so I felt strongly about voting to uphold the decision for that reason, in addition to it being the correct ruling following our rules. In summary, trying to relate an actual procedural vote to a different hypothetical vote I might or might not have taken is inappropriate. Even if we do follow that red herring argument, any votes related to this matter do not meet the financial interest definition of mandatory excusal. Despite that, I have previously excused myself from similar motions. I did not have the opportunity that day, as I mentioned, to make a decision one way or the other because it was quickly ruled out of order. Again, I see all of that as a bit of a red herring because what I voted on was purely procedural. Whether or not the president and really the Secretary of the Senate interpreted our rules correctly. Members have an undeniable right to vote on procedural issues. As such, I respectfully request that this ethics complaint against me is dismissed.
Thank you, Senator Miller. As in with others, we will go to Senator Miller for questions.
Thank you. Sorry for the demotion. He called you Senator Miller, so apologies.
What did I say?
That's the second time Senator Mitchell and I have been mixed up today, but that's okay. Mr. Chairman, Senator Mitchell, did I hear you correctly that you mentioned that you were planning to excuse yourself from the underlying motion? Did I hear you say that correctly?
Senator Mitchell.
As an aside, there is a clothing designer called Nicole Miller, and if I could say how many times I'd accidentally been called that, if I got an outfit for every time, my closet would be set. Senator Miller, I said that the two things happened so quickly, I really hadn't even had time to consider it. There hadn't been any debate or anything of that matter at that point.
I'm sorry, Mr. Chairman and Senator Mitchell, I misheard you. I thought you said you were planning to excuse yourself for the underlying motion, so I misheard you. My apologies.
Any other questions before we go to Senator Jaskowski, just in case he has any questions? But Senator Matthews.
Thank you, Mr. Chair. Senator Mitchell, the day in question, there was the jump up by Senator Frentz for making the point of order, but then there was a pretty lengthy debate about it, followed by a consultation by the co-presidents at the time, followed by a recess where they went back and confereed the decision of the co-presidents and all of that. So in all of that time, did you take time to consider the effects of, you said it moved so quickly that you didn't have time to consider whether or not to recuse yourself, but how the day played out, there likely would have been a substantial amount of time to contemplate that effect. Did you take that into consideration while the co-presidents were deliberating?
Senator Mitchell.
Senator Matthews, you were right. There was quite an extensive bit of debate on a lot of things. I believe I was focused on the motion or I'm not sure if it was a motion, but the out of order at the time and how compelling that argument was or wasn't. I tend to take the matters at hand as to what I'm considering at a given time.
Senator Matthews.
Thank you, Mr. President. You had acknowledged that a motion for ruling an expulsion vote out of order would be very different than a motion made by a member to rule any run-of-the-mill amendment on any bill that's before the body on the floor out of order. Do you consider those the same, or do you see the difference in those two?
Senator Mitchell.
Senator Matthews, I've never actually contemplated that. I guess I would have to do a more thorough study if I thought different motions out of order for different things were different weights.
Senator Matthews.
Thank you, Mr. President. Senator Mitchell, I think that's the crux of the argument. And there's a desire here to kind of finally split the hairs between whether the expulsion vote occurred or whether it was just a procedural vote to allow that expulsion vote to occur. And argument can easily be made that trying to hide behind that distinction is itself a red herring, because nobody's ever made any motion of ethics violation about a vote on any out of order ruling, on any amendment or anything else that typically goes on in the Senate, even though many of those have been with one vote margins, tied margins. Pretty much everyone's vote is essential in the outcome. But we had a very different scenario before us. And The employment aspect, I'll end on this note, Mr. President, is I believe it did hit you specifically much different than every other member, because it wasn't about any of the employment of all the senators at large. It was to one particular member, one particular situation. And that's why I think we've seen Senator Drazkowski come with this complaint about how this was the tie-breaking deciding vote on a motion as to whether the Senate would consider a particular disciplinary action. And real quick, into earlier comments made before we recessed, the reverse would not have been the same, Mr. President, had you decided to rule the other way, because a tie vote in that case would have kept the president's decision at hand. And so the vote of Senator Mitchell was only a tie-breaking scenario with the ruling and the result that took place. It would not have been that case had the ruling and the vote been for the other direction. So that's the crux of why this complaint's before us. Thank you, Mr. Chair.
Well, Senator Matthew, the issue is really clear that there was a point of order that was raised. The point of order was well taken. After deliberation, I came in and ruled, and that was appealed. We never, ever got to the motion to expel. That's the issue. That it was a procedural motion. No matter what could have been the result, like had I ruled differently, and that's not the issue. The issue is it was a procedural vote. It was to uphold the decision of the president. I recognize that you say, well, that prevented us from getting to the ultimate question. But the procedural issue is what was, that it's the procedural issue that is being discussed and brought before this body. Senator Matthews, before I see if Senator Drazkowski has any questions.
Thank you, Mr. Chair. Just a quick response, and I recognize that's the argument that you hold to and you want to make here, but very clearly that's not how it's viewed by many people that have that I hear from. I think a lot of Minnesotans have indicated, hey, it appears as a member voting on their own disciplinary action. And so I know that some members here may want to split hairs that way, but I don't think many people in the state of Minnesota see that way. I think many people think to their own circumstance that they would not have a say in their own disciplinary actions if it was done by them with their employer or whoever is the case. But that is something that an elected member of this body is trying to exercise. Thank
Senator
you.
Drazkowski, do you have any questions?
I do, Mr. Chair.
Senator Drazkowski.
Thank you, Mr. Chair. Senator Mitchell, Mason's section 522, number 1 says, it is a general rule that no members can vote on a question in which they have a direct personal or pecuniary interest. The right of members to represent their constituencies is of such major importance that members should be barred from voting on proposals of direct personal interest only in clear cases and when the proposal is particularly personal. So with that in mind, and that's what the contention is in this complaint, first of all, did you say earlier that if you were in a position to vote on a motion to expel, that you believe that is not a conflict of interest if you would vote on a motion to expel yourself?
Senator Mitchell, to the question, if you want to answer that.
I said that both following the standards under Mason, which even by what you said, well, first of all, we have an order of precedence in what we follow. And while Mason's is advisory, which is what you mentioned, statute is actually held above Mason's. And statute is what talks about the conflict of interest has to really boil down to assets. So it does not meet that, it does not meet that test. Also, you know, and I'm sure this could be for a literary journal at some point in time, but there is a genuine issue of senators being situated similarly when we're voting for things. So I use the bonding request. There are things I have voted for that really only benefited one person's district. That financially just helps them, but because it is in the role, they're allowed to vote on that. I won't speak to myself, but even a vote for expulsion, that person is there trying to represent their constituency. And if their constituency was saying, keep your job, take the vote, there would definitely be consideration there because that's what they're there to represent. Now, me personally, if it had gotten all the way to an expulsion vote, which is not even what the underlying motion was, it was just to eventually get us there. So now we're talking about a whole bunch of hypotheticals, which are not what I voted on that day. But had we actually gotten to the full expulsion vote, I would have made a choice to recuse myself. That would have been my decision. I'm not saying that's a decision everyone should make. I'm just saying I personally would have done that. But even that, under the rules, I would argue that wouldn't have been necessary.
Senator Drazkowski.
Thank you, Mr. Chair. So Senator Mitchell, in this whole discussion, do you believe that if a member votes on a resolution to expel themselves, that is not a conflict of interest?
Senator Mitchell.
Senator Drazkowski, I believe I just answered that question.
It's
Senator
really,
Drazkowski.
really yes or no question, Mr. Chair. Senator Mitchell.
Senator Mitchell.
Mr. Chair, I believe we vote on things all the time that have some level of conflict of interest because of the nature of our job.
Senator Drazkowski.
Thank you, Mr. Chair. Senator Mitchell, I guess we're not going to get a yes or no on that, but I think I heard what I heard. Senator Mitchell, do you receive a salary in your role as senator?
Senator Mitchell.
Senator Champion, yes, I receive this exact same salary as every other similarly situated senator.
Senator Drazkowski.
Thank you, Mr. Chair. So Senator Mitchell, that's $51,750 per year, right?
Senator Mitchell.
Senator Drazkowski, that sounds correct.
Senator Drazkowski.
Thank you, Mr. Chair. Senator Mitchell, are you eligible to receive per diem payments 7 days a week during the legislative session?
Senator Mitchell.
Senator Drazkowski, I am, just like every other senator in the Minnesota Senate.
Senator Drazkowski.
Thank you, Mr. Chair, and I believe that averages somewhere around $10,000 per senator. Senator Mitchell, as a legislature, are you eligible for state-paid insurance and benefits?
Senator Mitchell.
Senator Drazkowski, I am, although I will also say that I am fully able to get benefits through the VA as a 32-year military veteran with disability.
Senator Drazkowski.
Thank you, Mr. Chair. Thank you, Senator Mitchell. So, Senator Mitchell, if you were expelled from the Senate, would you no longer receive your salary and the other benefits that come with it?
Senator Mitchell.
Senator Drazkowski, yes, as would any other similarly situated senator.
Senator Drazkowski.
Thank you, Mr. Chair. Thank you, Senator Mitchell. So, Senator Mitchell, are you subject to the same requirements under Minnesota Statute 10A.07, our Senate rules, and the administrative policy, Senate rules 56.1, 56.3, 56.4, 10A.07 in statute, and administrative policy 1.35, just like every other senator is?
Senator Mitchell.
If every other senator is applicable to, then I would be as well.
Senator Drazkowski.
Thank you, Mr. Chair. Senator Mitchell, did you disclose that you had a conflict of interest on January 27th at any point?
Senator Mitchell,
Senator Drazkowski, as I've been abundantly clear, what I took that day was a procedural vote, and there was no level of conflict of interest in taking a procedural vote to uphold the ruling of the president.
Senator Drazkowski.
Well, thank you, Mr. Chair. Well, Senator Mitchell, that was a yes or no question as well. Senator Mitchell, Senator Westrom posed a question about your conflict of interest that you had in the face of that vote. Is there any reason you didn't take Senator Westrom's advice and not vote? Any particular reason?
Senator Mitchell.
Senator Drazkowski, I do not recall him having a direct conversation with me. I remember him making comments on the floor, but as I have repeatedly explained, following Minnesota statute, even with the underlying motion, there would not have been a conflict. I have previously, despite that, recused myself from similar votes in the past, and there was no conflict with making a vote on a purely procedural issue. So he did not have that conversation with me, and his points did not seem relevant to where we were at that time in our voting process.
Senator Drazkowski.
Thank you, Mr. Chair. Thank you, Senator Mitchell. Last question, Senator Mitchell. It's a yes or no question. Really, one-word answer will suffice. And 10A.07, subdivision 2D says, if an official is not permitted, so this would be, Senator Mitchell, the conflict of interest statutes give you there are 5 different musts or will nots in them, and you must take the following action if you have a conflict of interest. First, you must prepare a written statement describing the required action or decision, nature of the potential conflict of interest. Second one is you must deliver a copy of the statement to the presiding officer of the body of service. Thirdly, if a potential conflict of interest presents itself and there's sufficient time to comply with those earlier two, you must orally inform the superior or official body of service or committee of the body of the potential conflict. That would be the President of the Senate. And then, if you don't do all of those, or no, actually, and then also, it says the official shall not chair a meeting, participate in any vote, or offer any motion or discussion on the matter giving rise to the potential conflict of interest. And then lastly, the statute contemplates if someone, Senator Mitchell, has some sort of reason they forgot or things were rushed too quickly, you didn't have a chance to talk to President Champion, you were confused or whatever, and you go back to your office and you go, holy moly, they were inferring that I had a conflict of interest and I voted on the motion and I don't know if I should. I know probably every senator in the Senate would go back to their office, pull out the rules, look at the reference to 10A.07 and get down to 10A subdivision 2D. And that, Senator Mitchell, says, if an official is not permitted or is otherwise unable to abstain from action in connection with the matter, the official must file a statement describing the potential conflict and the action taken. A public official must file the statement with the board, that's the Campaign Finance Board, and a local official must file the statement with the governing body of the official's political subdivision. That wouldn't be applicable here. The statement must be filed within a week of the action taken. And so the question would be, after all of that, Senator Mitchell, and the ability to contemplate that, did you file with the Campaign Finance Board as outlined in 10A.07 subdivision 2D.
Senator Mitchell to the final question.
And Senator Champion, I will give this a yes or no question, but first, there was a lot to unpack in there, and I feel like I have the authority to do that. So that was a reading of much of statute 10A.07. I want to clarify that that statute is not just for legislators. It is for public officials, local elected officials, people appointed by metropolitan governments. So there is a lot of information in there that does or doesn't apply to the legislature. And that was actually one of my concerns about the complaint itself, is that within the statute, there are some areas that very clearly say, if a member of the legislature, then it's this. Whereas some of the other actions pretty clearly seem to be for other types of elected officials. For example, having to inform your superior supervisor, that really doesn't apply to us because we are essentially self-governing. So to say I was supposed to take actions that are clearly intended for other types of government official is really, to me, disingenuous. And to put that in an ethical complaint is disingenuous to abuse the statute and the writing of it in that way when there are such clear designations as to which portions are for legislators. But again, Senator Drazkowski has glossed over the very important part of that statute, which is, for purposes of this section, financial interest means ownership or control in an asset that has the potential to produce monetary return. That is under subdivision 1 in B. So again, we have extensively debated that part of the issue, and by not only what was stated in statute, but any cursory person's search of the internet, anything else, says that there was not an asset at stake. So even, again, the red herring of the underlying motion, had I voted there, it would not have met this standard. But once again, what I voted on that day was a purely procedural issue as whether a point of order was proper and whether or not to uphold the decision of the president.
All right.
There is nothing in statute that says there's ever a conflict taking that type of a vote. So to your question, no, I did not do what you asked because it did not apply.
So members, we will now go to, if there's any other members from the, questions from the committee. If not, Senator Drazkowski, if you can replace Senator Mitchell, because you get your 5 minutes of rebuttal. Members, we have to be out of this room by 12:15 because they've allowed us to be in here. But if we take a couple more minutes, by 12:15, if we take a couple minutes beyond that, I'm certain that they won't beat us up too much. But now Senator Drazkowski gets an opportunity for 5 minutes of uninterrupted rebuttal. Senator Drazkowski.
Thank you, Mr. Chair. Mr. Chair and members of the committee, thank you for taking the time to listen and consider our complaint today. This complaint is very simple. It is entirely about whether or not Senator Mitchell should have been allowed to participate in a vote that could determine her political future. On January 27th, the Senate had the opportunity to consider whether Senator Mitchell should be allowed to remain in the Minnesota Senate. A procedural vote prevented the consideration of a motion to expel. That procedural vote only required a simple majority vote to move to consider a motion to expel. That vote failed 33-33. As a result, Senator Mitchell literally cast the deciding vote to prevent the body from considering her own political future. There is no greater conflict of interest than preventing action that would result in a person's own removal from the Senate. Such a removal would eliminate a salary, benefits, and staff, along with the privileges to introduce, debate, and vote on legislation. In casting the deciding vote, we strongly argue Senator Mitchell violated 3 Senate rules of conduct. First, Senator Mitchell violated Senate Rule 56.4, which states members, quote, shall disclose potential conflicts of interest in the discharge of senatorial duties as provided in Minnesota Statute Section 10A.07, end quote. Senator Mitchell is the only person who stood to lose financial benefit from a vote on her expulsion, the only person. Second, Senator Mitchell's vote constitutes a violation of Senate Rule 56.1, which states, quote, members shall adhere to the highest standard of ethical conduct as embodied in the Minnesota Constitution, state law, and these rules, end quote. The most basic duty of an elected official is to put their constituents first. And elected officials who vote on issues in which they have a direct financial interest fail to adhere to the highest standards of conduct. Third, Senator Mitchell's vote constitutes a violation of Senate Rule 56.3, which states, quote, improper conduct includes conduct that violates a rule or administrative policy of the Senate, that violates the accepted norms of behavior, that betrays the public trust, or that tends to bring the Senate into dishonor or disrepute, end quote. Senator Mitchell's vote violated Senate policies which outlined very clearly how she should go about recusing herself from a vote, and she refused to take any of those steps. She betrayed the public trust by publicly putting her own personal financial interests ahead of the interests of the people of our state. It may seem like a small detail, but this little vote, a vote that just took minutes on the Senate floor, has the ability to set a lasting standard for our body. Do we consider it acceptable for a member to vote on something for which they stand to gain considerable financial benefit? Members, I ask, do we? Is there really so low of an ethical standard in this body that we don't consider it improper to conduct a vote on an action for which a member is the only person in the world who stands to benefit? The very reason we have rules of ethical conduct is to strengthen confidence in the decisions of the legislature among the public. Our constituents place an incredible trust in us to decide how to manage taxpayer resources and write laws to keep our communities safe and thriving. It's a trust none of us should take lightly, and we shouldn't let Minnesotans down. We should be affirming today that we have ethical standards to guide our actions, and we will not allow members to vote on issues for which they have a clear and direct financial interest. Thank you, Mr. Chair and members.
Thank you, members. Under 55.5, because this is the issue before us, I think we're pretty clear, unless there's no need to do an investigation because all the information is there. So if we want to do a formal motion on that, we can do that. Senator Kunish moves that that the committee does not proceed with an investigation. Is that your motion?
That is my motion.
Any discussion on that motion? Would you like a roll call?
Yes, please.
Roll call requested, roll call granted. Ms. Taylor Bennett will do the roll call. As fast as possible, because we got...
Senator Miller. Senator Matthews. Senator Kunish.
Yes.
Chair Champion.
Aye. That we not proceed with the investigation. Okay, the next is vote to defer action until a certain time. We think that we have all the information before us. Senator Kunis makes a motion that we do not defer until another time.
That is my motion.
With that being the motion that's before us, any discussion before we vote? Do you want a roll call vote?
Yes, please.
We have Senator Matthews.
Mr. Chair, I think that is the crux now that we're up to a minute away. The body's got to deliberate what the result will be. That is either direction likely going to take longer than a minute.
No, I think
Even last year when we had an additional complaint with Senator Gruenhagen, we gave ourselves time to come back and decide what the appropriate response would be. So I think that it's proper for this committee to do the same here in this case.
Senator Matthews, I do not agree because with Senator Gruenhagen, the circumstances were different. There were some things that we wanted Senator Gruenhagen to do and for leadership to do with him in order for that to be so. So I would disagree with that.
Mr. Chair,
Senator Matthews.
that was all what came out of the second day of the hearings, not what we'd said on the first day.
Okay, so I'm of the opinion that it doesn't, you can vote against her motion. If you like, you can certainly do that. And I don't see a motion for us to go in executive committee because I don't think that we would have the support in order to do that.
Mr. Chair.
Senator Matthews.
Mr. Chair, we'll be setting the standard here under custom and usage in the Senate of allowing members to have a direct say in the disciplinary actions made against them. And I don't think that that is the position that the Senate wants to put ourselves in. I think we need to hold ourselves to higher ethical conduct than that. And so I would urge us to reject the motion, and we can come up with some form of a resolution of what's appropriate in this case.
All right.
Mr. Chairman,
Senator Miller.
and I appreciate you thinking on my behalf, but that is not what I think. I would like to go into an executive session to.
Well, if you want to put the motion forward, you got to have three hands. Is that correct? All right. So if you want to put that motion forward.
Well, we have another motion in front of us, so I'll be voting no on this motion, and then I will make a motion
Okay, got it.
to make that motion.
So to Senator Kunis's motion for the committee not to defer action until a delayed time, there's been a roll call requested, roll call granted. Ms. Taylor Bennett.
Senator Miller.
No.
Senator Matthews.
No.
Senator Kunish.
Yes.
Chair Champion.
Yes. So that fails. Now we go to.
Mr. Chairman, I'd like to make a motion that we go into executive committee action,
All right.
meeting, whatever we call it.
Executive committee. Motion made for the committee to go into an executive committee. In order to do so, there has to be 3 votes.
I'll request a roll call.
Roll call requested, roll call granted.
Senator Miller.
Miller votes aye.
Senator Matthews. Senator Kunish.
No.
Chair Champion.
No. All right. We are now on, on the motion around whether there is probable cause. Senator Kunis, motion is that there is no finding of probable cause.
That is my motion.
Any discussion on that motion? Roll call requested, roll call granted. Senator Matthews.
Thank you, Mr. Chair. I believe this would be a mistake to pass the motion, even compared to what actions this committee has made within this session. So I think that some action does need to be warranted, and would ask members to vote against this motion.
Senator Miller.
Mr. Chairman, can you just explain to us what a yes vote means and what a no vote means?
Yes vote means that you believe that there should be a finding of probable cause. A no vote means you do not. And if there is a tie, there's an impasse, and the result of that is that this complaint does not go forward. It just sits there.
Okay, so a yes vote is you believe there's probable cause, and a no vote is you do not believe there's probable cause.
That's correct.
Thank you.
All right. Roll call has been requested. Roll call granted.
Senator Miller.
Yes.
Senator Matthews. Yes. Senator Kunish.
No.
Chair Champion.
No. There have been 2 for and 2 against. It fails. With that, there is nothing else before the body, and we will resume after the trial of Senator Miller. Excuse me, Senator Mitchell. I'm sorry, Senator Miller. Just to
Unless, Mr. Chairman?
Yes, unless there's new information that is provided.
Thank you.
Because that was my commitment that we would certainly do that, and I still stand by that. With that being said, the Subcommittee on Ethics is adjourned.